premised on Section 16, brackets 1, brackets A, brackets Roman figure 1 of the Superior Courts Act, number 10 of 2013. The section reads as follows, I quote, 16 appeals generally. 1. Subject to Section 15.1, the Constitution and any other law. A. An appeal against any decision of division of as a court of first instance lies upon leave being granted. Roman figure 1. If the court constituted of a single judge, either to the Supreme Court of Appeal or to a full bench of that division, depending on the direction issued in terms of Section 17.6. Close quotes. Section 1 of the Act defines an appeal thus. 1. Definitions. In this Act, unless the context otherwise indicates, an appeal in Chapter 5 does not include an appeal in a matter regulated in terms of the Criminal Procedure Act, 1977, brackets, Act 51 of 1977, close brackets, or in terms of any other criminal procedure law, close quotes. Section 16.1A1, relied upon by the applicants, falls under Chapter 5 of the Act. The leave to appeal, therefore, thereof, is predicated on a wrong act and section and deserves to be struck off or dismissed on this ground alone. The background and the grounds upon which these applications are based need to be ventilated because of the clandestine manner in which the application was brought. When the trial started on the 8th of October 2018, Mr. Doberman brought an application objecting to the charges and sought an order to quash the charges. After argument, I issued the following order refusing the quashing of the charges. I quote, I most probably shall furnish reasons during the trial or at the end of the trial itself, close quotes. I further ordered the state to furnish the defense with further particulars required. The state obliged. Thereafter, the evidence of Ms. Cheryl Zondi was led and cross-examination started. While her cross-examination continued, an application for my recusal was brought on notice of motion. The founding affidavit stated succinctly the grounds relied upon. I shall not regurgitate these grounds as they were properly addressed in my reasons for refusing to recuse myself. Suffice to say that the new grounds based on facts not foreshadowed in the recusal application surfaced in the application for leave to appeal, which was argued immediately after I gave reasons. It has to be borne in mind that the applications for leave to appeal were served a day before the reasons were given. The application for leave itself is convoluted. It does not delineate questions of fact from those of the law. The words of my brother Chetty J, dealing with a leave application to appeal in the matter of Panayoti, resonate with this matter where he stated, I quote, procedurally, the grounds upon which an application for leave to appeal are predicated are required to be clearly and succinctly tabulated in unambiguous terms to enable both the prosecuting authority and the court to determine its parameters. The first applicant's notice of motion for leave to appeal is unfortunately not a model of clarity and offends against the spirit and purport of Section 316 of the Criminal Procedure Act. It constitutes an amalgam of inane and vituperative comment and is moreover interspersed with a belligerent innuendo. Such deficiencies ordinarily warrant that the application be struck from the roll, but to do so would ultimately serve no useful purpose as merely delay the inevitable outcome of this application, close quotes. I was taken aback when I discovered that the application for leave to appeal encompassed, quote unquote, an appeal against the order refusing the quashing of charges. That was in spite of there being no application for leave to appeal that order. After the charges were put, the applicants refused to plead to the charges on the advice of Mr. Doberman. I entered a plea of not guilty on their behalf in terms of Section 109 of the Criminal Procedure Act. The trial proceeded thereafter. No reasons were sought, nor was there an application for leave noted in pursuit of an order. It is outstanding under such circumstances to learn for the first time in the application for leave to appeal that I refused to furnish reasons for my order. The order I made needs no elucidation. The trial is at its infancy stage, so to speak. As alluded to, new grounds emerged on the notice of application for leave and at argument stage. As a reminder or refresher, it is the duty of a legal representative to represent his or her client to the best of his or her ability. But foremost, it is the duty of that legal representative to strive at all costs to assist the court at arriving at a proper and just decision at all times, and not to endeavor or use strategies which shall set the court up for failure. Again, in an unprecedented manner, Mr. Price, in his oral argument, referred for the first time to an instance where Ms. Zondi was shown a copy of a ticket where the first applicant was in America. The background to this aspect can be gleaned from the record. The cross-examination went as follows. I quote, "All right, let's just go back. We are in Durban now. You have gone to Durban. You are in the house. You want to get away from this man, and he is raping you every other day, as I understand you. Is that correct?" "Yes, sir." "Virtually every day, is that correct?" "Majority of the week, he was doing this to me." Question, from Monday to Sunday, the majority of the week, which means virtually every day. Is that correct? The answer, every other day, yes. Every other day, yes. Not every single day. Not every single day, yes. And did this continue for the entire period while you were in Durban until you escaped? Yes, I am sad to say it did. I beg your pardon? Yes, I am sad to say that it did. Every other day, every week, for the entire period while you were there? Yes, sir. Is that correct? Yes. You were staying at the house? Yes. So for that entire period, you were staying at the house. Is that your evidence? Yes, sir. Are you quite sure about that? Yes. He would only leave. He would only go to his wife's home to check on them. He would not stay there. He stayed with us. He was sleeping there. Yes, he was sleeping in the house with us. Yes. Yes, yes. And he slept there every night throughout that period until you escaped. Is that correct? Yes, sir. Is that your evidence? Yes, sir. Are you quite clear on that? Yes, sir. You can't be making a mistake? No. Are you sure? Very sure. All right. I want to show you a printout of a certain flight tickets. Have a look at this. Have a look at it, please. Is this, that was a question. The answer, is this his trip to America? I've underlined this portion. Yes. That you are going to talk about? Yes. I had forgotten about it. My mistake. Well, that is very unfortunate. Answer, it happens. Just have a look at the ticket. You will see it is from Flight Center. Shall we mark it with the next number, Your Lordship? A few questions, close quotes. A few questions down the line, I made the following remark. Court, I just want to make an observation here, Mr. Doberman. Mr. Doberman, yes. Court, that the witness mentioned that trip to America even before she saw the ticket. Are we all in agreement in respect of that? Mr. Doberman, well, she mentioned the trip to America. Court, when you were just handing in or showing her the ticket, but before she could see it. Mr. Doberman, yes, yes, I'm in agreement. The court, okay. Mr. Doberman, before she saw it, she mentioned it. Court, okay, thanks. No, that is what I wanted. Thank you. Had I not raised, close quotes rather, had I not raised this, the record as it stands and as seen from the underlined portion, would not have shown that the answer was given even before Ms. Zondi saw the ticket. At the stage when I said this, I had an idea in my mind of the style and line of questioning the defense was pursuing. Hence, I wanted that to be reflected on the record. It is astonishing to hear Mr. Price raising that for the first time in argument, that the applicants perceived it to be biased in favor of the state. It is disconcerting to hear the assertion for the first time in the application for leave to appeal that I allegedly had a cozy relationship with the complainant because I repeatedly made the following comments, I quote, that she wished to rest, sit down, take a break, and asking her from time to time if she was still fine, The Honorable Court was unduly close to the complainant and was attempting to mollycoddle her, close quotes. This submission is disingenuous. It is deliberately taken out of context. The anguish Ms. Zondi was in at the time she testified is abundantly clear. She was continually getting emotional, shedding tears, and breaking down at times. Because the matter is broadcast live on various television networks and social media platforms, her condition in the witness box is public knowledge. It was during those moments that I used the impugned expressions. Those moments are not reflected in the record. I shall not conduct this trial by prefacing such statements by saying, for example, I quote, I can see you are crying or emotional. Are you still okay? Don't you need a break? Do you wish us to adjourn to allow you to compose yourself? Close quotes. As I was steeped in the trial, I was able to pick up and formulate the strategy the defense was pursuing. I made it a point that those silent parts of the evidence be thoroughly explained so that the record reflects them. That is why I asked Mr. Doberman, as I did about the ticket to America. Had I not been wise to do so, a submission similar to the one dealt with in paragraphs 8 and 9 above would have been made. As aforementioned, presiding officers rely heavily in their function on the assistance of the legal practitioners who are first and foremost officers of the court. Adjudication of cases is not a game. It is not about who wins and who loses. It's about doing justice. The primary and ultimate duty of each officer of the court is to see to it that justice is not only seen to be done, but it is done. The test whether leave to appeal should be granted or not is the reasonable prospect of success. It is tried without the need to cite any authority that leave to appeal may only be given where the judge or judges concerned are of the opinion that the appeal would have a reasonable prospect of success, or there is some other compelling reason why the appeal should be heard, including conflicting judgments on the merits under consideration. I exhaustively dealt with the grounds set out in the notice of motion by the applicants, and I need not regurgitate them. I stand by them in deciding these applications. I've also dealt with those grounds which were either raised in application for leave to appeal or in argument. I have addressed them and need not repeat them. Applying the test, I am of the view that there are no reasonable prospects of success, nor are there any compelling reasons why I should grant it. Consequently, I make the following order. The applications for leave to appeal are dismissed.